Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's Webcast, Section 101 Patent Eligibility Update. I'm Naoki Yoshida, and I'll be your moderator today. It's my pleasure to welcome our presenters, Susan Tull and Chris Jones. As you may be aware, many cases have been decided since the Alice case, and a number of guidelines have been issued from the USPTO. But we still seems to be in murky waters when it comes to patent eligibility issues. Both Susan and Chris have experience in dealing with patent eligibility problems before courts and the USPTO, and will share with us their views on these evolving issues. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. This is an interactive webinar. Just click on the red Q&A button at the lower center of the webcast interface and type your questions into the Q&A window. Then click Submit. The questions will be answered today during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And we hope you can join us on November 14th for the next program in the series, PTAB Lessons Learned. To register, please click on the webcast link in the resources list. And now I will turn it over to Susan and Chris to begin our presentation, Section 101 Patent Eligibility Update. Welcome, Susan and Chris. The floor is yours.
Thank you so much, Naoki, and good morning and good afternoon to everybody. My name is Susan Tull, and I'll be starting our presentation today on Section 101, our update on patent eligibility. And we'll begin today with a brief review of Section 101, a discussion of recent Federal Circuit decisions, a review of PTO guidelines that have recently issued. We'll have a discussion of lessons learned, and then finally we'll turn to questions from you, our audience. So Section 101 stems from 35 U.S.C. 101, and that only states that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. So on its face, 35 U.S.C. 101 is a pretty simple statute, but over the years we've received a number of tests and guidelines from both the Supreme Court and Federal Circuit that have made interpreting and applying Section 101 a trickier prospect for practitioners, and that's what we're going to focus on here today. And this begins with what have become known as the Alice-Mayo tests. And these are from Supreme Court cases, the Alice case and the Mayo case, in which the Supreme Court enunciated a two-step process to determine whether a device met the requirements of Section 101 and thus contained patent-eligible subject matter, or if it did not meet the requirements of Section 101 and therefore was not or did not contain patent-eligible subject matter. And so the first step is that the invention, the claim, and the patent has to be to a process, machine, manufacture, or composition of matter. If you don't fall within one of those categories, then you don't pass Section 101. You do not have patent-eligible subject matter. But the additional two-step test that I'm about to go into is what was enunciated fairly recently by the Supreme Court in Alice. And the first question is the claim directed to a law of nature, a natural phenomenon, or an abstract idea? And these are judicial exceptions to 101 that the court has carved out. And the idea is that you cannot claim a law of nature. You cannot claim gravity, for example. You cannot claim a natural phenomenon or an abstract idea. I cannot claim the famous equation E equals mc squared as a patentable idea. I cannot claim the three laws of thermodynamics in order to get a patent of those. So if it's directed to a law of nature, then you have to go to the second step in the Alice-Mayo test. And the question is, does the claim recite additional elements that amount to significantly more than the judicial exception? And so that means, does it recite additional elements that amount to significantly more than the law of nature, natural phenomenon, or abstract idea? And if the claim does recite additional elements that do add significantly more, then you can still get a patent. It meets the requirements of 101, and it contains patent-eligible subject matter. But if the claims do not recite additional elements that amount to significantly more, then you do not pass that test, and you do not have patent-eligible subject matter. So in order to pass the requirements for 101, you must either not have a claim directed to the law of nature, natural phenomena, or abstract idea, or if you do, your claim must recite these additional elements that add significantly more to the judicial exception. And the two-step test, while somewhat simple on its face, has been, again, difficult for the courts to apply, and has resulted in a number of opinions and guidelines that have come out on this issue. And so with that, we're going to turn now to the review of recent Federal Circuit decisions that help shed light on what does that two-step test mean, and what can practitioners take away from that test in terms of what is or is not patent-eligible subject matter. And so with that, I'm going to turn it over to Chris to start our discussion of these recent Federal Circuit decisions.
Thank you, Susan. Hi, everybody. I'm Chris Johns. As Susan mentioned, the Supreme Court gave us this two-step test that she mentioned on the previous slide of determining whether a patent is eligible. Determine first whether the claims are directed to a judicial exception, and if so, determine whether the claim recites additional elements that are significantly more than that judicial exception. But in those cases, in the Alice and Mayo cases, the Supreme Court actually explained that they would not tell us what abstract idea means, and they would not explain what significantly more means. They said, we've already decided numerous cases on what those mean, so that will be the guidepost. But it isn't very helpful, especially in the modern age where we deal a lot with software, we deal a lot with computers and electronics, and that's where most innovation happens, at least a lot of innovation these days. So it's difficult to look at older cases and make sense of it with this new case law that lays down this two-step test. We have received some guidance, mostly from the Federal Circuit. In 2016, the Federal Circuit decided the Enfish versus Microsoft case. This case related to a patent for improvements to data storage. It included what was called a self-referential table that improved upon how data would be stored and accessed in a database. The court found that it was a specific implementation of a solution to a problem in the software arts, and determined that the claims would be eligible. Now, the teaching point here on what directed to means is that determining whether a claim in a patent is directed to an abstract idea requires determining the character as a whole of the claim. It's not just whether the claim involves the abstract idea or judicial exception. It's whether the character as a whole, when considered in its totality, is directed to that concept, that exception. So, as Susan mentioned before, if you were to write a claim that claimed E equals mc squared or the three laws of thermodynamics, the claim would be directed to that because that's the character of the claim. But using those concepts may be eligible because the claim may not be directed to those concepts. We received similar clarifying guidance in the McRow case, which came out about a year and a half later. It dealt with improvements to 3D animated speech generation. It used rules to turn a timed transcript for animation into weights that were used to morph a three-dimensional computer-generated character face to make it appear as if it was speaking. And the court noted that it was different from the manual process and also found those claims eligible. And the teaching point from this case is that there's a line between something that is a specific means or method that improves technology and happens to use an abstract idea in some way, and that would be potentially eligible, or a result or effect that itself is the abstract idea. So again, to go back to, say, the law of gravity, you can't claim the law of gravity. That would be just the result or the effect that is the abstract idea or judicial exception. But if you have a specific means or method that improves technology and merely happens to use that exception, it may be patent eligible. And so that's step one of the Alice Mayo case. We have received some guidance on what it means to be significantly more. That is, whether the additional elements in the claim render the claim patent eligible. We received these two decisions in fairly quick succession in February 2018, the Berkheimer case and the Atrix software case. And these were interesting because they laid down what it means to be significantly more. The Berkheimer case related to a system for eliminating redundant data in a data storage system. And the district court found the claims to be ineligible under the Alice and Mayo test. The Federal Circuit, which is our reviewing court, they found that while certain claims were ineligible, there were a couple of claims that they said may raise a genuine issue of material fact as to whether they recited significantly more than the abstract idea. And this was interesting because the Patent Office and some courts had been deciding cases based purely on legal issues. That is, there would be no consideration of facts or evidence, declarations, anything of that nature to determine whether or not claimed elements were significantly more. And the Federal Circuit said, well, we have to use some sort of guidepost, and it needs to be a factual determination. It's something that we can't decide without going to the facts of the situation. These decisions make it they've made it more difficult in recent months for motions for summary judgment to invalidate claims under Section 101, because if the patent owner or the plaintiff in some cases is able to raise the idea that there's a genuine question of material fact as to whether the claims are recite significantly more or are not drawn to an abstract idea, the court would be less likely to simply grant that motion and invalidate the claims. So we've seen a little bit of an uptick after Berkheimer and Atrix that cases are going to trial or some sort of decision is being rendered based on the facts. And one thing to add about the Berkheimer case that was important, especially for later when we talk about Patent Office procedure, the court explained that it was not enough to merely find those additional elements existing in some prior art document or existing somewhere in the past. Whatever evidence was being relied upon needed to make clear that those elements were well understood, routine, and conventional. So for example, if finding a single U.S. patent that mentions those elements would not be sufficient, but an elementary college textbook on the subject may be sufficient because it establishes that it's a well understood concept in the field. We've also received some guidance from the Federal Circuit that applied the Berkheimer and Atrix requirement to perform to do fact finding in this BSG Technologies case. The Federal Circuit applied the Alice test. The claims were directed to a self-evolving generic index to enable users to input information into a database more efficiently. Under step 1, the court found that the claims were directed to the abstract idea, i.e. the judicial exception of considering historical usage information when inputting data. In step 2, the plaintiff argued that the unconventional features in the claims were enabling users to be guided by summary, comparison, and usage information or historical usage information when inputting that information. And the court said that that's part of the abstract idea. It's not enough, even under Berkheimer and Atrix, even given all the facts, to merely build upon or narrow the abstract idea as part of the improvement. The improvement needs to actually improve something in technology that isn't necessarily part of the abstract idea itself. So this case is sort of a counterpoint to the Berkheimer and Atrix case, because even though all of the facts were considered, there still wasn't enough for this BSG, the patent owners who save these claims. Now I'll turn it back over to Susan to talk about another case involving the use of mathematical equations, which came out in a patent eligible way.
Thanks, Chris. And so we're going to talk next about the Salas case. And this is a 2017 Federal Circuit decision. And this case is important because it is a claim that involves software. The claims involve algorithms and mathematical equations, but the Federal Circuit still found that the claims were directed to patent-eligible subject matter and found that those claims passed the test for Section 101. So in this case, the claims were directed to the idea of using multiple sensors to track the motion and determine the location of an object with respect to a moving reference frame, with respect to those motion sensors that were moving. And in this instance, the patent was originally heard by the Court of Federal Claims, and the Court of Federal Claims found that the claims were ineligible under Section 101. And the Court of Federal Claims reasoning was that the patent was only using laws of nature governing motion to track the location of objects, and therefore it was solely directed to an abstract idea. The Federal Circuit reversed this decision, and in doing so, the court provided some reasoning that is very useful for patent owners and patent applicants who are looking to patent and protect software. And so the court focused again on the Alice two-step process, and it really focused on the question of what are the claims directed to. And here the court found that the claims were nearly indistinguishable from those in an earlier case, the Deere case, and noted that the equations that were used by the claim invention were used in conjunction with an unconventional utilization of the inertial sensors. So here again, the court was really going to what is the heart of the invention. And the Federal Circuit noted that the claims did not tie up the equations or the use of physics principles themselves. So it didn't mean that no other patentee could claim motion sensing or the equations used to calculate the location of an object with respect to a moving frame of reference. The claims were only seeking the protection of the application of law of nature to the unconventional configuration of senses. And what the court found is that the claims were not only directed to the abstract idea of using math equations for determining the relative position of a moving object to a moving reference frame, but instead found that the claims were directed to systems and methods that use sensors in a non-conventional manner to reduce the errors in measuring position. And here again, the court really focused in on that first step of the Alice-Mayo test that we've been talking about. What are the claims directed to? And I think one of the key takeaways from this case is that merely using equations or algorithms does not mean that your invention is automatically ineligible under Section 101. But the question is, some of the questions that the court asked are you tying up those equations or the laws of nature such that nobody else can utilize those equations in their claimed invention? Are you solely directed to those principles or equations, or are you directed to something else? And here it was the configuration of sensors. So I think the key takeaway is really knowing that while we've been talking about 101 and there's been a lot of talk about the restrictions on software, that there is still a way through for software patents and Section 101 patents and software patents and algorithm patents to prevail under Section 101. And we're also seeing that in the USPTO, and in fact, the U.S. Patent Office has issued guidelines in the past year on Section 101 in light of the recent Federal Circuit cases that we've been discussing. And I know that Chris has in fact been dealing with these guidelines and with the Patent Office a fair amount on Section 101. So I'm going to turn this section over to Chris.
Thanks, Susan. It's actually as nerdy as it sounds. 101 is a big passion of mine. The PTO has issued a lot of guidance in the past couple years. Certainly this year has been some of the more important guidance in terms of getting patents past that 101 hurdle at the Patent Office. For a number of years, it seemed that a lot of the guidance coming out of the Patent Office was more negative than positive. But we had a number of cases this year that I'll discuss in this section that were positive, pro-eligibility, and established some clear guideposts that patent applicants would be wise to look at when writing, when preparing patent applications as well as prosecuting them. So starting with the first one that was important this year, in early April, the Patent Office issued a memorandum addressing two cases. The first was the Finnegan versus Blue Coat case, and the second was the Core Wireless versus LG Electronics case. Both of these cases came out in January of this year, and it took them a couple of months for the Patent Office to issue these guidelines based on them. But once they did, it was fairly helpful. The Finnegan case related to a method of virus scanning. It would scan an application program, generate a security profile that would identify any potentially suspicious code or problems with the program, and link the profile with the application. So when they were downloaded, the user or whatever system downloaded it would have that profile along with it. The court found the claims to be not abstract at step one. The court said this claim method recites specific steps that accomplish a result that realizes this improvement in computer functionality. It enabled the user to be protected against previously unknown viruses, obfuscated code, other potential hostile operations that improved over traditional virus scanning systems. Interestingly enough, the Patent Office is one of their first things they did after the Alice case came out in 2014 was released a list of examples. The very first example related to malicious code isolation. And there are some similarities that the Patent Office pointed out between the Finnegan case and the malicious code isolation case. And so in writing this memo, they said, this comports with their understanding of the case law at the time as well as currently. The court finding the claims not abstract did not continue on to step two to consider whether the claims recited significantly more because there was no need to do so. The second case they addressed in this early April guideline was the Core Wireless case. And this invention in the claims involved a graphical user interface for a smaller screen that would display an application summary of the a summary of the application that's on sort of a main screen or a main menu while those applications are unlaunched, that is, not running. This would enable the user, this interface would enable the user to then request certain information or perform functionality in that application while it's not launched. And that was a kind of important distinction. The court focused on the fact that these claims, in addition to being directed to an improved user interface for particular electronic devices, the claims were narrowly tailored to an improvement in technology and not just generally to, as the defendant tried to pursue the idea of an index or the concept of, enabling access. It was directed to a specific improvement in technology. It improved upon conventional user interfaces, and again, because it was not abstract, the Federal Circuit did not move on to step 2. And these two cases have been very helpful as part of kind of a toolkit at the Patent Office when we receive an office action. The Finnegan case in particular, it discusses a lot of the idea of, what is the particular technology you're improving and how are you improving it? And if you can explain that to the satisfaction of the patent examiner or the Board of Patent Appeals, should you need to, that goes along, this Finnegan case especially goes a long way to establishing that what you have is an improvement on technology and not just an abstract concept. So these cases have been very helpful, and receiving the guidance on them has been very helpful as well. The next guidelines that we received were related to the Berkheimer and Atrix cases that we mentioned earlier. The idea, again, being that determining whether or not the additional elements represent well understood, routine, and conventional activity is a factual determination. And this memo laid it out in a very clear manner for examiners. And one thing to know about U.S. patent examiners, most of them are not legally trained. They're not lawyers. So they don't necessarily have a deep understanding of every case. These guidelines are very helpful because they explain to the patent examiners how to apply these tests that each of the courts come out with. So by explaining that this is a factual determination requiring facts, it explains to the examiners that they can't examine things as if it's a matter of law as they used to. They need to provide some sort of evidence or some sort of assertion that the evidence is available or point to something that would explain their position. Notably, the memo explains that it follows this determination of whether elements are well understood, routine, and conventional follows the same analysis as the Section 112A analysis for enablement and written description. That is, if it's not well understood, routine, and conventional, the specification should explain that in there somehow. There should be some evidence of that, and there should be some discussion of those elements. And you can run into an interesting problem where if you are trying to rely on certain elements, but you don't have them in your specification, then instead of a rejection under Section 101, you may get a rejection under Section 112. This is just, and this will tie in later when we talk about strategies in front of the Patent Office, but it's important to try to point out the technical advantages and any other advantages you can think of when drafting the application to begin with. The memo did explain that it's different from a 102 and a prior art analysis, 102 and 103, which again is important to explain to examiners that there's a different way of doing these things. And the final point, which is the most important, is that it required the examiner to cite to particular evidence in order to support the argument that certain elements are not, that they're directed to, they recite well understood, routine, and conventional concepts. Examiners need to provide either an admission in the specification that the elements are well understood, routine, and conventional, an admission made during prosecution, for example, in response to an official office action from the examiner, a court case that held those elements conventional or discussed the conventionality of them, or some sort of publication or patent that establishes that those elements were conventional. And as I mentioned before, and the memo emphasizes this well, it's important that the elements not just be found in a single publication. The memo explains that the publication, whatever it is, needs to point out that those elements, those concepts, were well understood, routine, and conventional. So again, an entry-level university textbook, or even a high school level textbook, or something of that nature that explains that those concepts are so fundamental and well understood, then they were well understood at the time that the application was filed, is the sort of evidence that the examiners need to provide. In a lot of cases, patent examiners are not necessarily providing that evidence. They may provide one or two patents or a publication, but this is one point that is important to note whenever you have an office action from an examiner, because this is one way of attacking the examiner's positions. So now we'll move on to a lessons learned section where we can discuss what we've gotten out of these cases and how to use these cases to your benefit, both in litigation and the prosecution realms. And Susan will start us off in this section.
Thanks, Chris. So we know that a lot of innovation is moving away from a pure hardware device, and that software is at the core of many of our new innovations. And in the past, software algorithms have been frequently treated as abstract ideas by both the U.S. Patent Office and the courts if there's litigation over a patent. And so it's very important to consider 101 in addition to the other patentability requirements when preparing and prosecuting an application. In the past, before the Supreme Court enunciated the Alice and Mayo test, Section 101 was a pretty easy hurdle to clear, and nobody ever really addressed it or gave it much thought. But now, particularly if you have a software-related idea, it's very important to consider 101 when you're drafting your patent, when you're prosecuting it, and you'll likely, if you're a patent owner, face 101 challenges in a litigation as well. It's also important to revisit any pending patent applications during the design and development process to ensure that your claims are directed to eligible subject matter while covering your product. So if you are programming the software and the source code, and that program and the algorithms change over the prototyping and development period, you want to ensure that you are covering your product to the extent possible in your patent application while making sure that you still meet the Section 101 challenges that we've been discussing. A couple of takeaways that I think we can glean from the cases that we've been discussing, these recent Federal Circuit cases and Patent Office guidelines, is that if you are faced with an early Section 101 challenge in litigation, such as a motion to dismiss or a motion for summary judgment, and you are the patent holder in that instance, you'll want to consider arguing that a factual determination is required, that Chris mentioned with respect to the Berkheimer case, and that can be a way to stave off or put off a Section 101 decision early in a case before you've had a chance to develop your case, to take discovery, to obtain expert opinion on this issue. And any time that you put an issue before the jury on something like this, the jury may be more open to arguments about why something is unconventional and why it adds significantly more than a judge may, who would be listening to this on an incomplete factual record and considering it only as a matter of law. So the Berkheimer decision really has opened the door for patent holders in a litigation to try to push back this decision until later in the litigation once fact discovery has been completed. And also, as Chris discussed, if you are faced with a Section 101 rejection at the Patent Office, check to make sure that the Patent Office guidelines have been met. Did they cite that specific evidence, that list that they are required to identify in order to make the determination that the additional elements are in fact only conventional and well-known in the art? And what we can also glean from these cases is that a non-conventional arrangement of generic conventional pieces can be patent eligible, and we saw that in the Thales case. We also saw that use of a mathematical equation in the claim system or method does not make the claim abstract, but the claim must include other non-generic or non-abstract elements. When arguing and drafting, when drafting a claim or arguing over the issue of subject matter eligibility, it's important to consider the claim elements both individually and as a whole when arguing non-conventionality, because the courts will focus on the question of what is the claim directed to, not only what a single element is directed to. And then as a patent holder or a patent applicant, you can argue that the claimed method or system improves prior art technology or improves the functionality of a generic computer in an attempt to meet the Section 101 requirement or to overcome a Section 101 challenge if you're in a litigation where that issue is raised. And we also have a series of lessons learned relating to patent drafting and what to do as the patent applicant in this case. And for that, I'll turn it over to Chris.
Thank you, Susan. So as Susan mentioned, we have some lessons learned from the Supreme Court Alice and Mayo case, cases from the Federal Circuit cases, from the USPTO guidance we've received on how best to draft a patent application so as to avoid or at least cut short the amount of time you need to spend on dealing with Section 101. And our first kind of lesson that we focus on is what we like to call pre-budding 101, to put work in before the application is filed to rebut the idea that the claims are ineligible as being directed to an abstract idea without significantly more, by putting in evidence and other sort of framing topics or framing concepts to show that the application is not merely an abstract concept. You want to strategically write these applications. You frame them as an improvement upon technology, and not merely, for example, a business method or a method of performing a simple task in a slightly faster way. You take what was conventional. You explain that the prior art performed this particular task or had this particular system that operated or was constructed in this way, and it suffered from these disadvantages. Either explicit references to prior art systems or sort of more vague references help as well, to just explain the state of the art at the time the invention was filed, and to say these prior solutions to this same problem or this similar problem were good, but they failed for this reason, or they suffered from this disadvantage, or they just weren't fast enough for some reason. And that's when you present what you've created. Test data is great for this. Whenever we have an application and there's test data that shows improvements in an algorithm, improvements in a process, improvements in a system through quantifiable data, that is something that's very helpful to put in an application because it shows to the patent examiner that there is an actual technical improvement and it's quantifiable. That's something that's worth considering putting in. And this goes towards how you describe your invention really matters. When you write the application, you want to make it sound as if it's an improvement to technology and an improvement to a particular type of technology. One idea that we do a lot of times is take an invention that may be directed to something that the Patent Office has historically rejected claims relating to that a lot. For example, financial systems, business methods, computer software-related inventions. Framing that application in a particular way to target a specific U.S. classification is very helpful. Instead of writing an application as a system that decides where financial data should go, framing it as an application of an artificial intelligence system gives it a more technical flair. And so instead of being reviewed by a patent examiner in the financial or business methods area, it might be reviewed by an examiner in the artificial intelligence area, which is known to give fewer rejections under Section 101. And the same goes for how you claim your invention. I used to be a patent examiner, so what would happen was an application would come into the Patent Office, and the patent classifiers would review the claims and review the specification quickly to determine where it should fall, in what area it should go. Should it be a business method? Is it a cryptography application? Is it artificial intelligence? Is it related to network technology? Is it related to computer vision? And it would send the application. They would send the application to that art unit for examination. Targeting the application to particular art units that are known to not give rejections under 101 as frequently is strategically a good way of avoiding those rejections and avoiding that problem during prosecution. Another idea is considering multiple applications to recite the different use cases and different software improvements you have. So potentially the applications will go to separate art units or be examined by different examiners, and that can separate out sort of the concepts that you have that may run into problems under Section 101 from the concepts that you have that may be more technical in nature and easier to explain why there are improvements in technology. And our next and final section is a Q&A section. And I believe, Naoki, you may want to take over.
Okay. Well, thank you, Susan and Chris. Before we begin the question and answer portion of our event, please take a moment to complete our brief evaluation survey. As we strive to provide programs of value and continually improve, we would appreciate your input, which will guide us in planning future programs. Okay, it is now time to address questions from the audience. And as a reminder, to participate in the Q&A, just click on the Q&A button and type your question into the Q&A window, and then click Submit. So it looks like we have already multiple questions, and we'll try to answer them as many as we can. And okay, the first question is we have from the audience is, what do you think is the source of the hostility toward the business methods patents and the software patents in the USPTO and the courts? Let's see, Susan, do you want to stab at it?
Sure. And I think an important thing to remember is that a lot of what we've been discussing, and in particular this Alice and Mayo test, have been questions that have been raised following the Supreme Court's guidance in this issue. So I don't think it's truly a hostility, and particularly not a hostility from the Patent Office or the Federal Circuit, but a question or a confusion about what the Supreme Court's test means and how it should be applied. And so I think when these decisions first came out, everyone was really trying to test the metes and bounds of what the Alice two-step test was. And I think that the initial pendulum swing was towards the side of ineligibility, but I think we've been seeing now from the Federal Circuit and in the recent PTO guidelines that we've been discussing a shift back towards finding these types of methods patent eligible. And Chris, I believe that we've talked about this in the past. I believe that you have some ideas on this topic as well.
Definitely. I think that there's a certain there's been a lot of public focus and attention to not just issues under Section 101, but business method patents and software patents in recent years, because the whole concept is relatively new. We've only had business method and software patents have some flavor of eligibility in this country since the late 90s, early 2000s. So there's been more attention from the public, and thus more attention from Congress and from the courts and from the public agencies that deal with patents. That's in some cases led to bad publicity. I agree with Susan. I wouldn't say it's hostility, but there's definitely more attention on this concept than in the past. Patents were not, they were in focus before then, but this is something that as we move towards an information economy, software patents, computer patents, they become more and more important and ever present in our lives. Who among us has not used an Android or an iPhone, and those have all been targeted by numerous patent lawsuits around the world. So I think public attention is driving some of this, certainly.
Okay, thank you. The second question we have from the audience is do you think Section 101 has to be read only in conjunction with Section 112? Perhaps, Chris, you want to start with that question?
Sure. Yeah, I think it's an interesting question. There's definitely a lot of sort of theoretical overlap between the two in terms of trying to explain what your invention is and finding the boundaries of both what it improves, where it is, and what you invented, and whether one of ordinary skill could pick up what you've done and do it themselves. These are definitely all interrelated issues. And what I find most interesting is that the Patent Office, since Berkheimer came out and since the memo came out, I've seen an uptick in patent examiners issuing enablement rejections, stating that the claims are not supported by the specification to such a degree to enable a person of skill in the art to actually perform or make that item, or make the invention. And there are elements that sound a lot like 101 in there, because it's sort of there isn't a significantly more, or there isn't a technology to it. The examiners will say rather that there isn't enough in the specification. So they're not, I wouldn't say they're tied together, but I'd say they're certainly related in a way. I'd also say there's a relation between 101 and 103, the obviousness test, because the way that the Supreme Court laid it down and a lot of the ways that the lower courts have been dealing with Section 101 issues sounds more like Section 103, obviousness, just in terms of trying to find whether there's been an invention or not. Susan, I'm not sure if you have any additional thoughts on that.
Sure. Thanks, Chris. I think from the perspective of litigation, when you are the patent holder who is facing challenges under any patentability requirement, you always want to try to keep the tests separate, as long as that works to your benefit, of course. So if you are challenged under Section 101, I think you'd want to argue to the court that this is a separate analysis and that it shouldn't be confused with 112 or 103, as Chris was mentioning, because a lot of times what a defendant who is attempting to invalidate a patent will attempt to preview other arguments in a 101 argument. So they may say the claim is directed to ineligible subject matter, and as part of that, they argue that there are no additional elements that are unconventional, that were not known in the prior art and aren't routine. And then as part of that, they'll basically preview their 103 obviousness case to the court and talk about how everything was known in the prior art and really isn't it obvious. And what you need to remind the court is If you are facing a 101 challenge, then it is only the 101 challenge and only the 101 standards that should apply, and that is what the court should bear in mind. And you want to be sure that your patent isn't made to be viewed in a negative light because a defendant is attempting to throw all of these other arguments and all of these other tests into the 101 argument. There may be times when you have a very strong written description and there's a lot of detail in the specification that would lend to both a strong enablement argument and a strong 101 argument, and in that instance you may want to pull some of that in as the patentee, but typically you want to keep those tests and those challenges separate in the court's mind from a litigation perspective.
Okay, thank you. We have the third question from the audience, which is the Supreme Court likely to weigh in on Section 101 again? Do you have any views on this? Maybe we'll go with Chris.
It's hard to say. They issued a number of patent cases. There were a couple years where they had a number of patent cases come out that dealt with 101, they dealt with damages, they dealt with infringement. I think it's tough to say whether there's going to be any patent cases on the court's docket in the next year or so. I know that today there was a big fight about the current confirmation of the next Supreme Court justice. I don't think they'll pick up 101 necessarily very soon. I think they're waiting for a better case to come up. They're waiting for something that really lays out more of the test to decide that. But that said, I think there's been a lot of talk in Congress about amending Section 101 either to simplify it or eliminate it to avoid all of these issues, which on one hand would be very nice, but on the other hand, we have a lot of decided law and it would just go away. I don't. We'll have to see what pans out, but at the moment, I don't see the Supreme Court addressing it anytime soon.
Okay, thank you, Chris. The fourth question we have is what is the general views of patentability of a method of treatment of diseases and the method of testing drug equivalence? Susan, perhaps you want to address this?
Sure, thank you. And we've been focusing a lot on software during this discussion, but there is an entire line of cases and PTO guidance directed to life sciences, medical diagnoses, and medical treatment as well. And those types of technologies are also affected by Section 101. And a lot of times, the challenge that they face is the argument that the invention is simply a natural phenomenon. And the Federal Circuit has recently issued a decision. It came out April of 2018 called Vanda Pharmaceuticals. And there, the Federal Circuit helped shift the pendulum back towards patent subject matter eligibility for these types of technologies. And at issue here, the claims were directed to determining a specific genotype, obtaining a biological sample, performing an assay, and then administering specific dose ranges of a specific drug depending upon the genotype. And the lower court had found that to be directed to a natural phenomenon, which was simply the determination of the genotype and then the treatment of the genotype and the reaction of the genotype with the pharmaceutical product was natural phenomenon. And the Federal Circuit disagreed, and in particular, they found that this was not simply using the natural relationship between the genotype and the drug level, and instead was using a specific drug in a specific dosage with a specific genotype to yield a specific reaction. And so the Federal Circuit found that to be subject matter eligible. And we've seen a line of cases coming out of the Federal Circuit that essentially distinguish between claims that are directed to producing things, treating diseases, and that those types of claims are likely to be found patent eligible, while claims that are directed solely to observing or detecting the natural phenomenon, that itself is not patent eligible. And so it seems that the Federal Circuit cases are almost coming down between whether the claims are directed to just information, the diagnosis or the observation of a body's reaction in a given situation, that is more often found to be natural phenomenon and thus not patent eligible, as opposed to the treatment or the production of a particular biological matter or biological reaction that is more likely to be patent eligible. And the PTO in June issued guidelines following the Vanda case. And here the PTO clued in on this and noted that method of treatment claims which apply natural relationships as opposed to being directed to those natural relationships are subject matter eligible, and that the consideration here for the Patent Office is that method of treatment claims that practically apply natural relationships should be considered patent eligible. So the Patent Office is drawing a line between whether you are applying a natural relationship or if your claim is directed to it. So I think here again, we're seeing the pendulum shift back to patent eligible subject matter in the life science and diagnostic technology.
Thank you, Susan, for addressing the field a little bit different from what we've been addressing, software business method. That is a very detailed explanation. Next question we have from the audience is the Alice two-step analysis still applicable? And also, what can be done in view of Berkheimer? Do you guys, either Susan or Chris, have comments about the questions?
Sure. I can talk about it from the examination and prosecution standpoint. I think it's certainly still applicable. Berkheimer changed the type of inquiry that needs to be done under Step 2, but it didn't erase Step 2. We've still seen patents be invalidated under Step 2, really under Step 1 and Step 2, based on the fact that there was no genuine question of material fact. And the same is true at the Patent Office. It's still a little difficult these days to get things past the patent examiner, because trying to argue that certain elements are not well understood, routine, and conventional requires convincing the examiner to understand that the elements that make up the abstract idea are, let's say you have 6 elements in your claim. If the first 4 are drawn to the abstract concept, and the last 2 are what you would say is the non-conventional concept, you'd still need to pursue that dichotomy between the 2 and explain why those are not conventional. And there's still resistance in a lot of areas in the Patent Office to doing so. So it's certainly still relevant, and in view of Berkheimer, it makes it a little easier for prosecution, but it doesn't eliminate the 2-step process by any stretch.
Okay, thank you, Chris. I think we have one more question. That'll be the last question from the audience. The question is, what if the patent examiner wrongly determined which of the elements to be included in the abstract idea and not the additional elements? I guess, Chris, do you have any comments on that?
Yeah, I mean, we see this a lot where the patent examiner has, especially when the patent examiner determines that all of the elements are part of the abstract idea, and therefore there's nothing else to consider to be significantly more or not. Or if you have a claim that's directed to a processor with memory that has instructions, and they cause the processor to perform steps, the examiner may say, well, all of the steps are part of the abstract idea, and the processor and memory are conventional and well understood. And the best thing to do is to argue and say it's not, these elements are not part of the abstract idea. These are the concepts. This is the concept the examiner's identified, but this element and this element and this element simply do not fall under that abstract idea. One thing that we've done in a couple of responses is to point out just the sort of absurd nature of some of these office actions that we receive, to say, if this is the abstract idea, there's no way that this element is part of that. It's not related. It's technological. It's not abstract. It's not even arguably related to what the idea is. And sometimes it involves adding more elements to the claim to add something else that is not abstract. But it's something that you should definitely argue back and explain that it's not part of the abstract idea and the examiner has misapplied the test. I think that's the most important thing. That should be step one in your step one analysis.
Okay, well, thank you, Chris and Susan. And everyone, thank you for attending today's webcast, Section 101 Patent Eligibility Update. This presentation will be available on demand in the next week. Please look for an email from us with the address link. And this concludes today's Finnegan webcast. Thank you for participating and have a wonderful day.